Well, good morning and welcome to day 2 of the 2025 Indiana Farmers Market Forum. Thanks for joining us today. I'm Deb Troca, Executive Director of the Indiana Cooperative Development Center, and we're proud to host this year's forum. We have a fantastic lineup of topics and speakers today, and we're thrilled that you're here with us. So before we get started, just a few housekeeping notes. Please keep your microphones muted during the sessions. If you have questions, please drop them in the chat and our speakers will have a chance to respond at the end of their presentation. We are recording each session, so you'll be able to revisit materials or catch up on any sessions that you miss. And with that, we'll get started. Our first speaker today is Wendy Chen, staff attorney at the Center for Agriculture and Food Systems at Vermont Law and Graduate School. She also serves as the board vice president of Food Connects, a nonprofit organization that operates a food hub and farm-to-school program in southeastern Vermont. Before joining CAFS, Wendy spent 7 months working on a small diversified farm in western Massachusetts. Previously, she was an administrative law judge for the Vermont Department of Labor and an employment lawyer in private practice in Seattle. So welcome, Wendy. Thank you so much for being with us today.
Thank you so much for having me. So I'm really happy to be with you today to talk about managing common legal risks for farmers markets. And I am coming to you today from actually southeastern Vermont. So a little bit about the Center for Ag and Food Systems before I get into the substance. So CAF's mission is to equip students with professional expertise, provide law and policy support, and create broadly accessible resources to cultivate a just agriculture and food system. We work closely with local, regional, and national partners to address challenges that span the food system. Challenges related to food access and security, farmland access, farm workers and other food system workers' rights, and public health, among others. We provide legal and policy support to respond to our partners' needs, and we develop resources that empower the communities they serve. Resources like the Farmers Market Legal Toolkit. And of course, because we are in an academic institution, we include students in the work we do. Through our Food and Agriculture Clinic, our research assistant program, and our summer honors internship program, law and policy students work directly on projects alongside our partners. So in today's session, I'm going to introduce y'all to the Farmers Market Legal Toolkit, which is at farmersmarketlegaltoolkit.org. I'm going to summarize some of the risk management tools that are presented in the toolkit. And then I'm going to talk in a little bit more depth, although it's still sort of an overview presentation about common legal risks and how to manage them. There should also be time at the end for questions. And of course, there's a lot more information about managing risks and other issues relevant to farmers markets in the Farmers Market Legal Toolkit. And I should just say at the outset that the content in the toolkit and in today's session is general legal information for educational purposes only. The content is not legal advice. Every farmer's market circumstances are unique. State laws vary, and laws, regulations, and guidelines do change over time. So for legal advice, we recommend that you consult with an attorney licensed in your state. So the toolkit. So this is one of CAF's national resources. It's something we developed in partnership with the Farmers Market Coalition and the Northeast Organic Farming Association of Vermont. And it was meant to provide open source legal tools to help farmers market operators as they make decisions to build and grow their markets. The specific topics that were covered were selected in response to recurring questions from market operators about how business structure affects their organizations, about how to make their products accessible by accepting SNAP, and about the types of legal risks their markets face and how to manage them. We launched the toolkit in January 2018, and we have added new resources as new legal questions arise. Two of the most recent new resources are about independent contractors and volunteers at farmers markets, and those were published in the last year. So risk management tools. So I'm going to spend a few minutes kind of describing 4 of the tools that markets can use to help manage their legal risks. First is governance, or more specifically, business structure. Next one is insurance. Then there's market rules and procedures, and then record keeping. And for risk management purposes, it's important to know the liability implications of a market's business structure for the market owners, officers, and directors. If a market is a sole proprietorship or a partnership, the law is going to treat the owners and the market as one and the same and not separate legal entities. What that means is that creditors can get to the owner's personal assets to satisfy the market's business liabilities, which would include things like unpaid rent or a judgment from a lawsuit. If a market is a limited liability company or a for-profit, nonprofit, or cooperative corporation, market leaders generally won't have personal, individual legal responsibility for business liabilities just because they happen to be market leaders. Leaders are still going to have personal legal responsibility for their own wrongful acts, of course. For example, if for some reason a board member decide to trip someone on purpose at market day, they're still going to be individually liable for any harm that results. So most farmers markets are going to have many years of incident-free operations, but unfortunate accidents and disputes can, and they do occur. When an issue does escalate into a lawsuit, attorney fees and settlement or judgment costs can really threaten a market's financial stability or even its viability. Even when those lawsuits are dropped or lost at the end of the day, the time and money that's needed to handle the issue can really challenge a market. So insurance is really important. Insurance is not perfect. It does not cover everything that could possibly happen, but it can help provide a market with a partner to identify and manage legal risks, an attorney to defend against a covered claim, and of course, a source of money to pay for a covered claim. And there are various types of insurance because an insurance policy is a contract, and like any other contract, the words in that policy are paramount. An insurance policy is going to lay out all the terms of coverage, what it covers, what it doesn't cover, to what extent it covers it, and under what conditions it will cover a claim. And an insurance company is not going to pay on a claim that isn't covered in the policy. So to make insurance work as a risk management tool, market leaders really do need to understand the specifics of their policy. And probably the most common and important type of insurance for a market to have is commercial general liability insurance, or CGL insurance. Some people think that that type of insurance is going to cover a business for pretty much everything bad that can happen, but it doesn't. And that's why there are all these other types of insurance. What CGL generally does cover is claims that are made by others against the market for causing bodily or personal injury or property damage that's the result of the market's negligence. CGL generally does not cover a market's vehicles or property, which is why auto and property insurance can be important. CGL usually doesn't cover the market if a market leader causes harm to the market and how they are managing the market. And it also doesn't protect the individual market leaders for any wrongful acts they engage in that might harm the market. That's what directors and officers liability insurance is for. And potential claims that D&O would cover would be things like breach of a duty of care or a duty of loyalty or the misuse of funds. Those aren't real common claims, but they can happen. Um, Another category that CGL doesn't usually cover is illness or injury to employees. And that's because that is what workers' compensation insurance is for. Workers' comp covers any injury or illness employee might get in the scope of their employment with the market, regardless of who's at fault or if anyone's at fault. Most markets that have any employees are going to be required to purchase workers' comp, although that depends a little bit on your particular state. Um, and workers' comp, you should know that that usually covers employees, not other workers who aren't considered employees, like independent contractors or volunteers. And finally, just to mention that CGL usually doesn't cover claims from employees for things like discrimination, sexual harassment, retaliation, and or wrongful discharge. That is generally what employment practices liability insurance is for. Um, one important thing to know about EPL insurance is that it doesn't usually cover or is really limited in covering claims from employees for misclassification and things like minimum wage violations or overtime violations or workers' comp violations. Um, and so if the farmer's market has CGL insurance, that usually is not going to cover the market's vendors unless that's discussed and agreed upon and part of the policy. And that's one reason why vendors should probably be required to have their own CGL insurance. Because they're handling the food at markets, product liability insurance might also be a good idea for vendors, because that would cover them for claims that's a product they sold caused injury or illness. And I would say, in addition to a market maybe requiring their vendors to have insurance, they might want to have their vendors actually include the market on their insurance policy as an additional insured. And what that would mean is that the vendor's coverage would extend to the market. And if both are the vendor and the market are sued for something, it would be the vendor's policy that would cover both. Another thing markets could consider is requiring their vendors to designate the market as a certificate of insurance holder. And all that really means is that the market would have a right to be notified if the policy lapses or there are any changes to the policy. So rules and procedures, those I think are the most effective at preventing issues that can put a market at risk. Making sure vendors adhere to safety standards that can help prevent injury and illness. Having efficient market day procedures can also help prevent accidents and also ensure smooth operations. Having clear rules and procedures for how vendors are selected or how they can display their products, that can help prevent disagreements. And having good dispute resolution procedures in place can help prevent disagreements from turning into lawsuits. And there are some best practices to keep in mind when implementing rules and procedures. The first is transparency. When markets are transparent in advance about how decisions are made, like vendor selection, they can really prevent problems before they even start, even sometimes when there's disagreement about the ultimate decision itself. Second is consistency. To be effective as a legal risk management strategy, rules and procedures really have to be followed and enforced consistently. As you can imagine, if a rule is enforced against one person but not another, people are going to start looking for reasons for that different treatment, and maybe think that there's some discrimination going on. Consistency in communicating rules and procedures to vendors and customers at the beginning and throughout the market season is also really important. Finally, discretion. So markets need to preserve their ability to make decisions without getting forced through an overly rigid process that doesn't account for extenuating circumstances. Markets should probably, I would recommend, include a statement with any rules document they might have, or vendor selection materials that clarifies who has the discretion to make the ultimate decision. And as I start talking about managing specific legal risk, I'm going to focus a lot on rules and procedures because, again, they are, I think, the most effective at prevention, whereas business structure, insurance, and record keeping, which I'll talk about in just a second, are, I think, more important for managing liability once something happens. And certainly good rules and procedures can also put a market in a stronger legal position if something does happen. Because when a market can show it has clear rules and procedures to maintain safety and compliance with the law, and that those rules and procedures are consistently followed, it's going to be in a better position to defend itself in the event a lawsuit is filed. And so all of the other risk management tools are most effective when there's underlying documentation that's properly created, maintained, and updated. On the left side of the slide is a list of some documents we suggest keeping as part of a legacy folder. And a legacy folder is basically a collection of documents, current and historical, about the market. Things like the incorporation documents and bylaws, insurance policies, etc. And having all of this information in one place and organized, probably electronically, that can create a lot of efficiencies for a market, especially during times of transition. And it can also reduce the potential for miscommunication and misunderstanding that can lead to legal action in a worst case scenario. We do actually have a new case study on the FMLT that talks about some legacy folder training that the Vermont Farmers Market Association did for markets in the state, if you're interested. Aside from documents in the legacy folder, markets should really have other records that reinforce their risk management strategy. It's really not enough to write policies and procedures, but never put them into action. And it's important for markets to be creating a paper trail to prove that they followed their policies and procedures. And safety procedures are the perfect example. Someone gets hurt at a market and sues. A market can protect itself if it has records to show that it follows safety procedures every market day. Similarly, it's not enough if a market has clear vendor selection criteria and application procedures. The market has to use those criteria and follow the procedures and prove they did so. For example, by keeping copies of vendor applications with notes of how each applicant stacked up against the pre-established criteria. And for vendor agreements and compliance documents, a signed document from a vendor that acknowledges they read, understood, and will abide by market rules is going to be much stronger evidence than oral testimony based on memory from a market leader many, weeks or months after the fact. And in markets also, it's helpful for them to be able to demonstrate how seriously they take safety by maintaining copies of insurance policies and licenses and permits and any other documents they might require of their vendors. So moving on to managing common legal risks. So I'm going to focus again my remarks a lot on rules and procedures, and then talk about how rules and procedures and some of the other risk management tools I just talked about can help manage risks related to personal injury and property damage, food-related illness, vendor and host site relationships, and employment law and ADA compliance. And personal injury and property damage are probably the biggest legal risk for farmers markets. And it may seem somewhat obvious, but I'm sure you can imagine someone slipping or tripping, falling, and hurting themselves at a market. So I'm just going to say, I do see that there's questions in the chat, and I am going to take them probably at the end, because otherwise I'll get too distracted and probably lose what I'm saying. So I hope that's okay. So things like wet grass, snow, ice, spilled liquids, potholes, that kind of thing. Equipment like electrical cords, tents and canopies, and vehicles and people in close proximity are all potential sources for accidents that can hurt someone or damage something. And if something does happen, there's a real possibility that the person who's hurt is going to ask the market to compensate them. And that will potentially be in a lawsuit. And legally, a farmer's market does have responsibility for the safety of its customers and its vendors. The market set up the event and it invited people into the event. If the market is drawing people into a hazardous situation, it can be considered negligent and therefore liable for any resulting personal injury or property damage. And again, it can be really costly for a market to face this kind of lawsuit, even if it wins at the end of the day. So on the right side of the screen, there's some talks about some ways that markets can use the risk management tools I talked about earlier to help manage these risks. So again, it's a good idea to choose a business structure that provides personal liability protections for market leaders. It's a good idea to purchase commercial general liability insurance, and this is really what the big thing that CGL covers, which is other people getting hurt at the market. Or having their property damaged. And it's really important, I think, for prevention to implement rules and procedures for market staff and vendors. Things like requiring folks to manage ground obstructions like equipment, produce, electrical cords, and tent equipment, requiring vendors to maintain clear walkways around their stalls, using specific types of weights, types of tent stabilizers or weights and placement for tent stabilizers, requiring folks be completely set up and have their vehicles in a permit pre-established location by a specific time, and only allow breakdown and vehicle transportation after specified closing time. And again, it's really important to make and keep records to prove that the market took reasonable steps to prevent incidents. Food-related illness also poses some legal risks for farmers markets. Again, just like with personal injury and property damage, if someone gets sick from food at a market, they're probably going to ask for some sort of compensation, potentially in a lawsuit against the market. And there are also often government regulations that are related to food safety. So even if no one gets sick, non-compliance is a legal risk for markets as well. Food sampling, on-site food preparation, and off-site food processing or preparation in particular are more likely to result in foodborne illness. And it's true that vendors are usually the ones handling food at a market, and they're going to bear most of the legal responsibility for food safety. And they're going to bear most of the responsibility for complying with food safety regulations. But markets can expose themselves to liability if they don't take reasonable steps to prevent issues and promote compliance. Again, it can be really costly if a market faces this kind of lawsuit, win or lose. I'm not going to go over all of the potential risk management tools that can help manage this risk that are on the right side of the screen, because it would be sort of repetitive. But I will just again stress that it's really important to implement rules for vendors to promote food safety. So things like requiring them to know and comply with all laws, regulations, and permitting or licensing requirements is important. Requiring them to provide the market with a copy of any required licenses, registrations, certifications, or permits. Markets can also consider requiring their vendors to get CGL or product liability insurance, or even require them to indemnify the market against legal liability, which would mean that if a vendor causes some sort of food-related illness and that costs the market some money in defense costs from a lawsuit or paying out compensation, the vendor would be agreeing to basically reimburse or cover those expenses for the market. So one procedure that I think is really critical for managing risks related to personal injury, property damage, and food-related illness is to do a market day safety check. Um, and having a market day procedure like this helps make safety precautions a really consistent part of the regular market routine. It's really helpful to use a checklist like this one. And this is a sample checklist that is in the print resources section of the Farmers Market Legal Toolkit. And market staff would use something like this as a guide to go as a guide for their process for checking for safety risks and ensuring a safe environment before the market opens. And again, in addition to preventing problems, if something does happen, using and keeping records of a checklist like this can show that the market is being diligent in trying to maintain a safe environment. This sample happens to be organized by topic area and type of risk. You might actually find it works better for your market to organize it in the order market staff would walk through the market and check things off. But this is, I think, a good sample to build off of. Another good procedure to implement is to create and maintain incident reports. For one thing, a lot of insurance policies require incident reporting. Second, doing so can help reduce the market's liability in the event of a lawsuit. And third, doing so can also help a market identify and address safety issues. This again is a sample incident report form from the toolkit that you can incorporate into your market's procedures and you can tailor it again. And I think having a form like this is helpful for guiding market staff in kind of knowing what information is important to gather when something does happen. So conflicts involving vendors are a real possibility, and they can compromise a market's success, even if they don't end up leading to a lawsuit. It's not uncommon, I think, for a vendor to disagree with a market decision, like their stall assignment, to disagree with another vendor's product selection or pricing, or for a vendor to violate a market rule. And most certainly, if a vendor violates a market rule, that can end up, depending on what the rule is, resulting in some sort of liability for the market. And I think that a market's business structure and insurance aren't as helpful in managing these legal risks as rules, procedures, and record keeping. And so having clear rules and procedures, those can really create predictability and accountability, which minimize the chance of conflict and the chance that any conflict is going to escalate into a lawsuit. It's helpful for farmers markets to have a consistent process for assessing vendor applications, and any application materials should reflect that process. A legally resilient application asks for whatever information is necessary to assess an applicant according to the the market's pre-established vendor eligibility criteria, not more and not less. Including that vendor selection criteria and the full market rules as part of the application materials can also be helpful to improve communication and efficiency. It's also important for markets to have a dispute resolution procedure to address conflicts between vendors. Many markets procedures include a few steps like submission of a written complaint, evaluation or investigation of that complaint, a proposal for an outcome or action steps, as well as an opportunity to appeal that outcome. Transparency of that overall dispute resolution process and giving vendors an opportunity to participate in improving it can also be helpful. And when there is a dispute between a vendor and the market decision maker, for example, over the decision maker's interpretation or enforcement of market rules, a slightly different process might make more sense. As part of that process, markets should really emphasize their discretionary power and affirm their right to take appropriate action for the market. With these types of disputes, markets might also want to consider having a sort of independent, neutral third party resolve those disputes. And that third party could be a professional mediator, a selected team of stakeholders, or maybe somebody from a farmer's market advocacy organization or state organization. And one specific procedure that can help manage legal risks that are related to vendors is to use an annual market vendor communication checklist. It's important to be really clear with rules and expectations for vendors, including early communications about applications to the market and communications throughout the season. This sample checklist from the toolkit kind of gives a reminder of the types of things that vendors should be notified about or reminded of before the start of every market season. Things like the rules and expectations for vendors, like providing copies of insurance or licenses and permits. An overview of how the market is going to communicate with vendors throughout the season in case of things like, extreme weather or emergencies. Um, a reminder about the logistics and requirements for vendors to set up their stalls, and also a reminder about the market SNAP policies and procedures if your market does accept SNAP. So most farmers markets, they don't operate on land that they own. They get permission to use somebody else's property to host the market. There are some legal risks that arise from that. Disagreements between the market and the host site about responsibility for safety or cleanup, disagreements between the market and the host site about the market's use of the site or the host site's use of the property for other purposes, violations of the host site's rules by the market or a vendor. Those can all jeopardize the market's continued use of the site or even lead to a lawsuit. So again, on the right side of the slide, there are some risk management tools to consider for managing this risk. What I think is really critical here is to have a written lease, rental agreement, or license with the property owner. Formal written agreements like a lease with the host site are really helpful for having clear expectations on both sides. And again, without clear expectations, you can imagine there will be could be disagreements out who keeps the site safe and clean, when the market can operate, and what else the host can use the site for. It's also important to implement rules for vendors. Usually when there's a lease or a rental agreement, there's often some sort of obligations that are going to be placed on the market, again, like cleaning up the market site after every market day. It's really important for markets to make sure their vendors understand and comply with those obligations, because as a legal matter, if a vendor violates the market's agreement with the host site, it's going to be the same thing as if the market itself violated the agreement, which again could jeopardize continued use of the site or result in some sort of money damages if there's any harm that comes to the site. So the proper classification of workers as employees, independent contractors, volunteers, or interns is fairly complex, and it is beyond the scope of this session. What's important to know is that if a market improperly classifies a worker as an independent contractor, a volunteer, or anything other than an employee, and therefore doesn't meet employment law obligations like minimum wage requirements, or pay for workers' comp insurance, or pay for unemployment insurance taxes, it can face some significant legal exposure, things like civil penalties, back pay or back taxes, and lawsuits for unpaid wages and benefits. Enforcement by workers and government regulators isn't uncommon. And so every market that uses workers, any workers, whether they're employees or non-employees like volunteers, should really research and understand employment laws in detail and talk to an employment lawyer if necessary. And to be frank, markets don't have a lot of ways to manage the risks of employment law violations once they have happened. So it's solid internal procedures that ensure market leaders understand employment law and properly classify workers can be very helpful for avoiding accidental or inadvertent noncompliance. And markets can consider specific rules and procedures like requiring training for market leaders on employment law, restricting the use of non-employee workers to certain positions or that type of thing, or requiring that the market seek an IRS or state agency classification determination before they hire a non-employee worker like an independent contractor. And business structure is not so helpful for managing this legal risk, and neither is insurance, as I kind of talked about before. The one important thing to know about business structure and employment law is that for-profit markets, for-profit businesses cannot legally use volunteer workers. Only nonprofit and public markets can. It is important to make and keep records for your workers, in part because a lot of employment laws actually have their own record keeping requirements, to maintain records for employees that include hours worked, rates of pay, regular and overtime wages, deductions and withholdings, and dates paid, that type of thing. And not keeping those mandatory records is a non-compliance issue in and of itself. And not keeping them can also make it really hard for a market to defend itself against a legal claim from an employee. Finally, I'm going to talk about the Americans with Disabilities Act, which is a federal law that prohibits businesses like farmers markets from discriminating against customers because of disability or perceived disability. And a lot of states have their own similar versions of disability discrimination laws. What can be a little complicated about the ADA is it doesn't just prohibit markets from excluding individuals with a disability from the market, but it also requires markets to provide reasonable modifications or accommodations that will allow people with a disability to access the market's services anyway. Markets aren't required to incur an undue burden or substantial difficulty or expense to provide accommodations, but exactly what a market has to do to satisfy the ADA depends on a variety of factors like the market's operating budget, its staffing, the specific layout and circumstances of the market site, and the cost of making any modifications. And violations of the ADA certainly can give rise to a lawsuit. Usually, generally speaking, CGL insurance doesn't cover ADA violations by places of public accommodation, which markets are generally. And so it's helpful to have rules and procedures that prevent particularly accidental or inadvertent non-compliance. Certainly, markets should have a statement in any rules document that says, we prohibit discrimination. But there are some other risk management procedures to consider. Um, there are a couple resources in the toolkit that markets might want to use, and those include an ADA compliance checklist and an ADA request log, which I'm going to show in just a moment. And actually, here is the ADA compliance checklist for template. So it is important for markets, rules, and procedures to contemplate the market's ADA obligations, both to prevent disability discrimination, but also to defend against a disability discrimination lawsuit if one is brought. This sample ADA compliance checklist kind of incorporates the various factors that help determine a market's accommodation obligations, like the operating budget and staffing and the cost of making modifications. Having something like this can also help a market
with the
demonstrate its ADA
cleaner.
compliance
Okay.
efforts in the
I
event of a lawsuit. Sorry, I just heard someone
Yeah.
talking.
I think someone had their mic not muted. So
Okay.
if you hadn't, please do so.
Gotcha. Okay. So also maintaining records of any ADA requests your market gets and how the market responded in a log like this sample one can help a market demonstrate its ADA compliance efforts in the event of a lawsuit. One other thing to mention is that the market day safety checks I talked about a short time ago, those can really help make sure also that the site is safe for people with physical disabilities, or also help make sure that any temporary accommodations that the market agreed to are in fact in place before the market opens. And then finally, I'm just going to close with this annual legal checkup document and procedure. A market's risk management strategy is not a set it and forget it situation. It's really important practice to mitigate legal risks. So an important practice to mitigate legal risk is to do an annual legal checkup. This sample from the toolkit provides a reminder of the types of things that should be double checked and potentially updated before the start of every market season to make sure that the market keeps itself in good legal health. And in this checkup that should happen every year at least, market leaders would review and update their business filings and insurance policies, make sure lease and rental agreements are up to date, make sure that their market rules and procedures are up to date and revised if needed, and also to make sure everything's in place for SNAP EBT compliance if your market does accept SNAP benefits. And with that, I am done. Sorry, I know I've talked a lot and probably fairly quickly, but I am happy to take questions in the last 10 or so minutes that we have.
Well, thank you, Wendy. There's one question in the chat about if we have someone type their name on a Google form to confirm that they've read and agree to abide by the handbook, is that adequate?
I think that is generally adequate for risk management purposes to show that somebody received and read and agrees to the market rules or the handbook. Yes, I don't think you necessarily, I think it's probably, I mean, it's of course, I guess you could say that it decreases the risk even further to get like a notarized signature, but I do think it is sufficient.
Okay, thank you. Next question. Someone found your website, but the legal toolkit documents, are they on the website or are they on the, where could they find those?
Yeah, so sorry, that is the Farmers Market Legal Toolkit is at farmersmarketlegaltoolkit.org. which is separate from the Center for Ag and Food Systems website. And it is on the slide now. There's a little QR code. And then on the toolkit, there's a section for print resources, and all the sort of forms and templates are in that section.
That's awesome. That will go a long ways to helping people get started with all of this. Are there other questions for Wendy?
And I do see one from Pam. What if a vendor feels that a market continues to single them out and makes them unable to sell their products anywhere? I don't, it's hard for me to say without knowing all the details, but I think this is one of the places that having a dispute resolution process would be helpful. Say if the vendor has a dispute with the market, kind of having a procedure that's set out about how to resolve that dispute. And if it ends up going, not being resolved right away, just with some conversation, then maybe it is having someone like a mediator or someone from an outside organization try to work that out with someone.
What about a market advisory committee to manage vendor disputes? Is that a good strategy?
You could do that. I mean, I think the point of having somebody else is that then it doesn't seem like it's just the market people taking the market people's side, and that there's sort of some neutrality and impartiality.
Any other questions for Wendy? That's some wonderful information, and thank you so much for sharing with us. If you have any other questions, feel free to unmute your mic and ask or drop them in the chat. And just as a heads up, Christina did put into the chat this evaluation for this session. So please take a moment after the session to complete that. We really would appreciate your feedback.
Yeah. And if
Going
you
forward.
have questions later on, you're welcome to email me, or there's a contact us function on the toolkit as well. And we do get inquiries through that, and we're happy to help as best we can, of course, with the caveat that we cannot give you legal advice.
Right.
I did have a quick question. I'm sorry, I can't type as fast as I'd like. But where would you recommend starting to find like a neutral person to kind of mediate a dispute between the market and a vendor?
Yeah, so one of the things to consider is, there's like an ag mediation program. I don't know, how it operates everywhere, but there was some in the last few years, there have been at least some places where they've expanded that to, a little bit more broadly than just like farmers, to other food system organizations. So you could try Googling basically like free ag mediation. And go start there. The other place I might start is like in Indiana, like if you've got the sort of state farmers market type association, seeing if somebody from that organization might be able to help, or give you some resources about who might be able to help. Or it could also just be talking with if you're with a market and you've got a dispute with a vendor, kind of talking with them about, who do you know someone in this community that you would trust, and that we can agree on to be like an independent sort of mediator.
Thank you.
You're welcome.
Any last questions for Wendy?
And the other thing I want to throw out there is, if there's something in the toolkit, or if you look at the toolkit and there's something where you're like, I really wish that the legal toolkit would address this issue. I hear it all the time and I can't find information about it. You're welcome to also use that sort of contact us function and let us know, because we always, when we start hearing like there's an issue of real interest to markets across the country, then we sometimes do develop new resources for that. That's how we ended up developing 2 resources related to sort of employment law issues last year.
Oh, that's awesome. Thank you for that.
You're welcome.
Well, Christina, do you want to let us know what's next on the agenda, please?
Yes, we have Shalise Lee with the Indiana Department of Health. She's going to be talking about nutrition incentives and this food as medicine program. So please join us at 11:15. We do take a quick 15-minute break. The session goes until 11. We'll be back at 11:15. It'll be a great presentation, a way to touch base with Indiana Department of Health and all the great programs that they implement and push out for farmers markets. So please come back and join us. And thank you, Wendy, for a fabulous presentation.
Thank you. And I do see a final question about free speech. And what I will say is, so there is a resource on the Farmers Market Legal Toolkit, and you can look in the print resources section about free speech at farmers markets. If you still have questions after that, feel free to reach out via the website or directly email me.
All right. Thanks again, everyone, for joining us for Wendy's presentation, and we'll see you at 11:15.
Thank you all for the invitation. It was nice to be with you.